a discussion between us, Lisa. Oh yeah. Yeah, we called this meeting mainly to just sort of get talking about some of those uh, first, most tracked bills that we looked at the last meeting. And I think those should have been sent to everybody. That's, SB 734, 813, 816, 237, and then House Bill 2472. We have somebody else joining, and I don't believe this is another commissioner, but maybe a member of the public or someone on behalf of somebody else. Good afternoon.
On behalf of me, she's listening in.
Oh, okay, gotcha. All right, so we have Ms. Flores on behalf of Kyle. Oh, we have okay, and then another person, Greenwald from OYA, listening in as a resource. Okay, so welcome everybody. So the purpose of today's meeting, laid out in the agenda, is to just talk about some of those bills. I think everyone was sent around a template to sort of look at where exactly these bills fit in with our with House Bill 2320 with Section 4, like our list of duties as JJPC, because I think everyone sort of noted a list of bills that would impact juvenile, but not everybody was able to put it in the duty areas for JJPC. So we wanted to be able to recognize some of those today. So I guess I'll just start. And yeah, I just want this to be a discussion. Again, I don't think we're going to be in any position, especially with just two of us here or three of us here, to vote on anything and make recommendations to the legislature. But really just want to get the ball rolling on how is this going to work going forward? What are some of the things we're concerned about, and what are some of the bills we want to be looking at? And also, when we're talking about, we're worried about this impact, this impact, this impact, maybe we can, keep a list there and say, when we meet with our subject matter experts at subsequent meetings, sort of ask them, to track those certain things. So I don't know. So Senate Bill 734. I don't know, Lisa, if you have thoughts on that one. I mean, I don't think it's bad. I think it's fine. I had a question about sort of the blanket wrap thing, but other than the blanket wrap device, and sort of what that would look like, and if there's other recommendations that an expert, in behavioral health, or mental health could give to facilities to make sure that they're using best practices. I didn't really have a whole lot of thoughts on sort of how this would affect, public safety, or sort of things in a larger sense. It's more about youth in facilities, is the way I read it. So yeah, I would definitely want to sort of know what the best practices are for youth experiencing behavioral health crises, and what can be used to keep, people in the facility safe, as well as the youth safe, without you know without them being further harmed psychologically by some of these restraints, which I think is the purpose of the bill. So yeah, I don't know if anyone else had thoughts on that, or things that they're worried about with that bill, or wanted to identify our area with JJPC that it focuses on. I certainly think it focuses on the best practices area. But yeah, go ahead, Lisa.
Since we're kind of having an informal meeting, I don't know, and I'm putting Addie and Debbie on the spot. I don't know if we can hear from OYA.
Yeah.
I understand that this follows some, this is a similar bill to a bill that was introduced a few sessions ago that restricted restraints on kids in DHS custody. And my understanding is, what I'd be interested in hearing is, I understand that some of these, some of the things that are outlined in this bill are not used by OYA at all.
And that's also my understanding. Yeah.
If there were things that are used, I guess that's where I would like to hear. And I don't know, the bill is not currently scheduled for a hearing, but I would just like some more information about what does this look like on the ground, if that's okay.
Yeah, well, Kyla, did you have something first?
No, dive in, go ahead.
Okay. And I'll just clarify too that it's not just about OA facilities. This bill also impacts county juvenile detention centers, so it's not just us. As Lisa, I'm sorry, I was like, is it Lisa? It's Lisa K. It's anyway, Lisa.
It's Lisa. I'm
I
sorry,
know.
my last name is Kay Williams. I'm sorry for all the confusion. I will forever be Lisa Kay because I changed my
know.
name too late, but I will respond to anything.
It throws me too because my mom's middle name was Kay, and so it just feels like a middle name to me. So anyway, my apologies. Back to business. So OIA did do an analysis on all the different restraint types that are listed in that bill. And the vast majority we do not use right now. And I'm just speaking for OA, I'm not speaking for county detention centers. There are two that we use that I'll just kind of, to Lisa's questions about like when are the circumstances we would use them. So we do use a transport blanket. And we use that when youth, for whatever reason, whether they were acting out due to a behavioral health issue or they were just being aggressive against other youth, and they need to be removed from that unit if they refuse to come with us willingly, then to safely transport them off of that unit, because we need to let the other youth on that unit get re-regulated, get their space back being safe. And we need to safely move that youth to another location. To not use a transport blanket, what happened in the past is that then you have them cuffed and you're lifting them up off the ground by their shoulders or their elbows, somehow trying to get them off the ground. And a couple of things could happen. One, you could get injuries to the youth. We have a lot of shoulder injuries to youth, or they're not well contained. So then you get a lot of staff injuries trying to do that. So the transport blanket, we put them in the blanket, we move them. As soon as we have them to the new location, we take the blanket off. It does not stay on them. It does not, we don't use it as any kind of containment. It is simply to safely move them from one location to another. And then the other one that we do use is the restraint chair. And we have it in 3 facilities, so we don't have it in all 9. We do have it in 3 of our facilities. And it is, again, we've used it a handful of times over the last several years, and it's all been about youth safety situations. So it is not by far the first thing that we go to when we have a youth that's not within, not regulated. I can give you a couple of examples, and I'm sorry, they're going to sound a little, a little tough, but to be really honest about what it is. So we had a youth that was self-harming, and well, both examples are self-harming. One youth was to the point that he was biting. We had taken away everything that could hurt him that he could use to hurt himself. And he was biting through his wrist to get to an artery in an attempt to, basically because he had no other way to cut his wrist open. So he was using his teeth. So a restraint chair, and it looks kind of like a roller coaster ride with the shoulder harnesses, at least the one we have, shoulder harnesses and kind of strapped in safely that way. So it didn't allow him access to continue to bite on his wrist. And we had tried multiple other interventions before we got to that point. The other example is a youth who was beating his head against the floor, and to the point that he'd given himself a concussion. He went off to the nurse's clinic, came back, started beating his head again against the wall. Like they were trying all kinds of things to have him stop doing that behavior. And the nurses were afraid that either he was going to make the concussion worse or that actually he could fracture his skull. I mean, he was hitting his head that hard. And so that was, again, just a way that we're trying to safely keep that youth from doing more damage to himself. So those are the times that we've used those 2 things, or how we use them. Did that help? Any other questions?
That didn't, do you guys have, is this tracked? How is your use of restraints tracked? And I guess I'll start with one question at a time.
Yeah, we, anytime that we put our hands on a youth for any kind of physical intervention, it is tracked in a youth incident report. So, and whatever our responses were during that intervention, we note that in those incident reports. So whether we used just physical intervention and no restraint systems of any kind, whether we took them off unit or didn't, the other thing is anytime we put our physical, even if we just physically put our hands on kids for an intervention, there's always a medical checkup afterwards with the nurses. So that's documented. And any other thing that the intervention they provide. So there's a multitude of things that are documented when we do an intervention.
And are there rules that outline what your process is? And I'm sorry, I did not look
Yes.
close enough. I see Addie shaking her head. Yes,
Yes,
that it's,
yeah.
is this explained in the OAR? And then my
I
next
don't know
question
that it's
is,
an OAR, but it's certainly in policy. Yeah.
oh, in policy, is that
Yeah.
policy is that a policy that you could share with this group?
Yes, absolutely. I don't have my hands on it because it's a facility policy, so I'm not quite as familiar with all of those, but I will certainly get it and get it out. Who would be the best person to send it to? Because I don't know that I have everybody that's in this group. So is there like a point person we could send it to?
Yeah, Debbie, if you want to send it to me, I can
Sure.
make sure it gets to the commission.
Yep, you bet. Thanks.
Thank you, Ryan. And I do have a follow-up question on that, Deborah, if that's okay.
Yeah, of course.
So when OYA, I hear that the chair is very rare. I knew about the blanket because I know that I've seen that used in Donald E. Long, just in a very intense situation one time where they've had to do that, which is why I sort of started with saying I don't really know what the alternative is to the blanket that I can think of in my, I'm not a professional in that area. But as being a former youth who has had to be in some sort of facility, I know that as a young person, when I had that happen and saw somebody with that happening to them, there's a part of me that's, wow, that's really horrible. You know, I hate that that's happening to them. But then there's this other part of me of, okay, I feel safer now because they're not going to get me. So that really is sort of a real concern there. So yeah, has OIA been given feedback by anybody on what like a best practice is in those scenarios other than the blanket? Like, do we have any, has anyone ever thought about that or?
What I could say is that our facilities policy advisor, when we added in the transport blanket as a part of our process, the people that make those decisions in our facilities division looked at a lot of best practices about how to do that safely, and they landed on that transport blanket. So I could see if what information they have that led us to that decision. I couldn't speak to what that was. That's not really I've been a policy advisor on the community side for a long time, so that's not really my side of things. But I do know that they had a lot of thoughtful, looking at different options before deciding on the transport blanket. And I want to stress too that that is only used when youth will not willingly go with us. I mean, our first approach was always like, hey, let's just take you off unit. Let's get you a timeout. Let's let you help calm down. We're not going to like, oh, you got to go off unit. Let's put you in the blanket to transport you. That is not our first approach at all.
Thank you.
Addie,
Addie,
we can't hear you. I know you're trying to say something.
brand new equipment. I'm
There
so
we go.
sorry. I would just add that as Debbie emphasized, that there's been a significant decrease in injuries to youth and staff since we've moved towards the use of the blanket, because the standard alternative of sort of cuffed and moving is particularly unsafe. And we did a quick review of sort of like best alternatives out there at the introduction of this bill, and that review remains to say that this is sort of the best alternative for this specific use as we've described it.
Went to unmute myself and turned off my camera. Thank you. That was helpful. Kyla? Or sorry, Chair Armstrong Romero.
It's totally fine. It's an informal meeting.
Cool.
I just wanted to clarify that this bill is really about mechanical restraints versus the soft restraint. And I know that in our OJDDA legislative committee, we've had a lot of conversations, the county juvenile departments, about the use of the wrap and the chair and this legislation. And I wanted to uplift that this legislation focuses on mechanical restraints, which are metal or plastic. And so, or the chair, which is specific, or the wrap. And so there's a lot of inconsistency across the juvenile detention facilities about who's using the wrap, who's using the chair. What I can tell you, and I know Vice Chair Rojo mentioned the Donald E. Long and the wrap. We don't use the wrap. We do use the transport blanket, which is different, and it's the soft version, right?
So, yeah,
but
I don't want to. Yeah, that's what I meant. I just
no,
wanted to
it's
speak here.
okay.
Yeah.
It's fine. I just wanted to put it on the record since that's my place. But we don't use the wrap, and we don't use we don't have a chair either. I think the pushback was not pushback, but the question was the ambiguity around mechanical restraints, especially as we're transporting youth. Because when we transport youth, we do use the mechanical restraints. So whether they're metal or plastic, like handcuff, shackle, things like that. There may be a court order where youth is required to be shackled before they come into the court in some jurisdictions, I've learned. And so I think that there's that question about when it's appropriate to be used that is not addressed in the proposed legislation. And similarly, there's a conversation from SOCAC, which is the System of Care Advisory Council, and they're introducing an omnibus bill around restraints for to, I guess, beef up what existed before for child welfare agencies to now include like foster care, etc. So, and those are two separate. But I did want to say the significant impact on the county juvenile departments, because we operate so differently, even though there are 9 to 11 of our facilities that exist across the state. We're vastly different.
Yeah, and I know in Washington County, at least, they do bring the kids in the mechanical restraints for hearings, and there are times where we have to make motions to remove the restraints for a trial or for something like that, and so it can, on some cases, get contentious. But yeah, it can be pretty devastating just at a regular hearing, setting a trial date for the family to just see the kid, just in sweats and they can barely move because they're just locked in these shackles. And then I'm having to meet with them in the back and they're still in the shackles and I'm having to beg to get them removed. So yeah, it's definitely an issue that yeah, we need some uniformity.
Part of
Lisa.
that, sorry. I just wanted to clarify. Part of that is that Washington County doesn't have a detention center. So currently, for now, the youth are taken from Donald E. Long by a sheriff, I believe, to Washington County. So of course they're coming in with the shackles and handcuffs because they're being transported. But then once they're in the court, then that's the jurisdiction of the judicial.
Right.
So
Lisa, you had
yeah, I'm just wondering if there's some for the county juvenile departments, is there some reporting that happens when youth are restrained, or is there some sort of like statewide report or review of practices, recognizing that practices might be different across jurisdictions? I mean, OIA is one entity. I know you have different facilities, but hopefully there's some ultimate review of the restraints that happen. But I'm just wondering, on a countywide basis, I know that can be difficult. I just don't know if it exists or if that would be something that's possible.
So I shared in the chat sorry. I'll pause.
No, go ahead. I was just saying I'm not aware of anything, so I got nothing.
So I shared in the chat the facility detention guidelines, which is what we follow. It's the best practices, and it was just updated in 2020. I think it's up for updating in the next year or so. But basically, it refers us to the best practices for when we use restraints, how we report those, how we document those. And as far as a statewide requirement to document mechanical restraints or restraints in general, there's not a requirement. However, every detention center has their own policy and their own format for reporting the restraints. And if they're an agency that is involved with PBIS, then PBIS requires us to, does everybody know? Do you know what PBIS is? It's part of the Center for Improving Juvenile Reform, but they're performance-based standards that nationally many juvenile detention centers, county juvenile detention centers, or local juvenile detention centers, they have reporting mechanisms, and it features information about safety, information about restraints, information about whether staff injuries happen and the frequency, and then it compares you to I can show you a sample report for restraint, and I can bring it up here in a moment. But I know that Cord had their hand raised, but I just wanted to say that, like, there are different reporting mechanisms, but standardized, no. The closest thing you'll find is PBS.
And Cord, did you have? Yeah.
I did. This is really a better question to be answered by Director Detman or by someone from the Prevention and Justice team at Youth Development Oregon, but the juvenile detention guidelines are something that our council and division, in conjunction with others, put together. I believe they are being updated right now. I know that there's a lot of reporting collected around secure facilities, but I don't know whether that includes any sort of incident reporting. I don't believe that it does. However, that's a little outside of my deep expertise. And yeah, so I see the chair shaking her head. So yeah, so basically, like, the little bit that I know is that others on my team and our director, who is on the commission, might be able to provide some information about what we do know or what we provide in terms of guidance.
Thank you for that feedback. Does anybody else have any other feedback that they'd like to add on this bill, or any other questions? Oh,
I would just say it sounds like there's lots of info. We aren't. I don't feel like I'm in a position to take a position today, because there's lots of information I don't have. But I do think that this is something that is really, really core to what the work of the policy commission could do. And I think that this is an example of, preparing us to take positions in the future when we have information. And I think we're asking all of the right questions. And I think that this is something that we can continue to get. We should continue to get information on. I am interested in the countywide, the reports that go out and how they're reviewed for best practices.
thank you, Lisa. Yeah, no, I totally agree. Yeah, today's meeting is really exactly what you said. We're not in a position to take a position on anything as of today, but I just really wanted to get the ball rolling on us talking about the issues going forward. Plus, at some point we'll get our subject matter experts into some of our meetings, and we'll be able to start talking to them about tasks that, things we're worried about, things we want tracked, data that we would like to see. So I think this is a really good jumping off point to start thinking about what data we're going to want to see from them. Yeah. And so I don't know who's showing the outcome measure data from Donald E. Long. If someone could let us, is that okay? It's Kyla again. So what do we got here?
This is a example of a report from PBS. And so it compares your detention center to the field average. And as you'll see, this is the injuries during the application of physical and or mechanical restraints. And we haven't had any since October of 2020. But there's a myriad of different reports that we can compile. And it's really helpful to have this information. But that's just one example of how we review data. And you have to pay for PBS. So I don't know how many counties actually do that. So I just wanted to uplift that.
Yeah, I'm gonna take a wild guess and say Washington County might not pay for it, but that's just my guess.
It's only if you have a detention facility. So while Washington,
so then yeah, we do pay for it because Multnomah County does. Yeah.
While Washington County is with Multnomah County until August 4th of 2025, because as you know, they've terminated their contract with Multnomah. And then the kids will be going to Marion County. And I don't quite know if Marion County has PBS, but it's a good question And I think that's something that, you know, our commission can look at, like, how are we comparing ourselves to the national field average in both the state facilities and the local facilities? And so I think that would be a really great question to ask. And also
And I
for
would say that I was just going to say that I think that the legislation that establishes our commission kind of requires us, from what I read, to compare ourselves to those national averages and those national best practices. So I would say that is exactly what we need to be comparing ourselves to. That's what we've been tasked to do. So yep, exactly on the right point there. Yeah, and I don't want to derail too much, but we brought up the kids being moved from Donald E. Long to Marion County. Lisa, I know you're a practitioner, at least in Multnomah County. I don't know if you take Washington County cases too, but I know that there was a discussion last week that we had with custody services about some, the logistics of that. And I personally, I don't really know how that's going to work. And yeah, I'm very worried about the outcomes for youth with that new policy, given how far it is from Washington County. It is a 2-hour round trip drive minimum with no traffic. And a lot of these kids who do end up incarcerated have very limited resources and very limited family resources already. So it's very concerning. That's nothing that we can do anything about right now here today, but I think that those issues too are probably something that the commission should, when we can make comments on it, or when we can talk about them, that we should. That's just my view on that, just because I think that it does affect a lot of youth. And I know that there are other counties that have to do it that way across the state. So maybe it's something where I'd encourage the juvenile attorneys out here to reach out to those counties to see how they've made it work and all of that. But
well, and I think, Vice Chair Rojo, if I may, it would be helpful, because these are conversations that we have within the Oregon Juvenile Directors Association meetings. And I think that it would be helpful to have maybe the juvenile directors who are impacted by whatever situation it is come and maybe talk to the JJPC, or maybe have a special session along with OJDDA to have the conversations, because Multnomah County, obviously that's my place and that's my experience, and we just experienced this with Clackamas County last year. So I think for us, in preparing youth to transition, it's a little bit easier for us to prepare youth to transition out of our facility. But then what happens when they get to their new facility, that would involve a conversation with the interim Washington County juvenile director, and then the Marion County detention folks, about how they'll involve family, et cetera, et cetera. And so I think it would be helpful for us to, like, when there are issues that come up like this one that are pretty grave, that we can bring that forward with the right people at the table.
absolutely. Lisa Kay.
Yeah, I would just say I support having a conversation about the use of detention facilities across the state. And I think that we have some youth who are 5 hours away from their families. And so especially in parts of Eastern Oregon, I think kids are traveling a really, really long distance, which impacts their ability to obviously to meet with family. But I think that this is sort of highlighting some of these issues about what, there's a lot of issues related to pretrial detention. And as the research shows, the use of pretrial detention sometimes significantly impacts what your disposition is later on. So I think it would be a great thing for us to look at a different meeting and get lots of clear information about where the facilities are, where kids are being held, how, rates of detention use, how long they're there, and really kind of dive into that.
Definitely another area for our subject matter experts to get a hold of and collect some data. Kyla, you had your hand up.
And Lisa, you reminded me, like, the impacts of legislation on our juvenile services, or our juvenile detention centers. So for example, SB 1008 passed, and that was a great feat. A lot of folks supported that measure passing. And what that was really the termination of automatic waivers for youth who've committed certain violent crimes. As a result of that, kids have had to wait in detention for much, much longer periods to either have their cases waived or resolved. And so we charge detention beds like daily bed rates. And for Multnomah County, we are one of the most expensive. Our bed rate is $619 per day per child. And that's like the cost of operations. And so I just wanted to uplift that when you have kids who are there for, one great example is that we have one who's there for over 800 days and still pending resolution of his case or of their case. And so I wanted to uplift that change is not something that has been widely discussed about the impacts, and there was no funding to support that legislative change, but the impact is great.
Yeah, that's a helpful comment. I can think of other impacts that were kind of unintended from 1008 as well. On the public defense side, just speaking as a juvenile attorney as well. I know when I joined the unit, it was considered a dependency heavy caseload generally. But when SB 1008 came around, again, I'm supportive of SB 1008. I'm glad that it passed just for my own reasons, but it did sort of up a lot of the work that juvenile attorneys have to do, just because it was, instead of going to the adult criminal attorneys, now it's going to juvenile attorneys. And so the caseload sort of just skyrocketed on juvenile measure 11s. And there's not really and this is an OPDC thing, where there's not really a way to bill those correctly, given the amount of work that they have. And so it's just, that was another unintended consequences, I think, from 1008. And so, I have also noticed that the kids are locked up for longer on those cases, especially when a waiver is filed. I think the quickest I had one resolve was about 11 months. So yeah, those can be quite lengthy detention stays that are pretty expensive and harmful for sure. I don't know if we have more on SB 734. Or if, again, I kind of derailed the conversation a little bit more into, but again, we are tasked with studying drivers of detention and those sort of things. So it's all related. But another bill that we had on our list was SB 813. I honestly didn't have a lot of thoughts on this one myself. It's about another extending which parties can petition for testing for communicable diseases, right? Yeah, so I don't know if anyone has thoughts on how this relates to the commission's duties, or has any other feedback on this bill that they wanted to share today.
I can give an update maybe from OJDDA and the conversations that we've had. Yeah. I don't know if that's appropriate if you want me to.
Again, informal meeting, we're just getting to talking ideas and things that we want to be studying. So I think that's fine.
So what I will say is that in juvenile detention, staff are exposed to bodily fluids during the intake process, while doing searches, and also throughout youth stay. And exposure can occur from a youth purposefully spitting or using other bodily fluids. Detention staff are in a caregiving role, and they respond to injuries that expose them to blood, vomit, urine, feces. So, and they also handle laundry and cleaning at the facility, which can be exposed through incidental contact. So overwhelmingly, we support, county juvenile directors support SB 813 because it adds a additional layer of protection for staff and facilities. And in the community, working conditions, which are sometimes less than ideal. And it also allows our staff an avenue to seek important health information if it's needed while working to support youth in our community. So that is a quick snapshot from the county juvenile directors.
Thank you for that, Kyla. We do have joining us Commissioner Molly Rogers. Welcome, Commissioner Rogers. We were just discussing Senate Bill 813. I don't know if you had any thoughts on that one. Kyla just shared sort of the county juvenile director's thoughts on that. So I don't know if you just share in those same thoughts, yourself, given your position, getting a thumbs up there, if you had anything else to add.
No, she did a great job. Yeah, truly, we're supportive of this one.
Okay, gotcha. Again, we're, as a commission, we are not taking a position, but everyone's being clear about where they're coming from and what their thoughts are. So I appreciate that. Are there any other comments on this bill? Not hearing anything. So we got about 15 minutes left before we would go to public comment. So let's go to Senate Bill 816 was another one on our list. Again, this one is about establishing local diversion plans and giving rulemaking authority, I believe, to OYA for that. So yeah, anybody with thoughts on Senate Bill 816, how it relates to the commission, and any feedback? Yes, Lisa Kay.
This was a bill that my office supports, and I think it just makes a technical amendment to the law that county diversion programs, these are programs that divert youth from a youth correctional facility. And the current statute says adjudicated youth, it adds youth. So county juvenile departments can work on diverting kids from a youth correctional facility from referral instead of waiting until adjudication. I think that has been the way the county diversion programs have functioned for a number of years. And I think that this is a technical fix and is a good thing. And I think it had a public hearing and it looks like it is going to move.
Well, speaking solely as a juvenile practitioner, I've got to agree with you that it does just seem like a technical term that I'm glad is in there, because yeah, I want to see more diversion for the kids pre-adjudication for sure. Are there any other comments on that one?
I'll raise my hand. Actually, Lisa Kay, you should have come and testified with me. That was great. So yes, it was a technical fix. Previous to 2019, it was more open, and then through some other technical fixes, it just restricted it down.
All right. Well, thank you. Okay, what is this? Okay. Oh, okay. This one, Senate Bill 237, very short to read. It is one section. And I personally think that it goes directly again to one of our duties for studying, drivers and demographics and collecting data on the youth in the system. So this one just it directs the Oregon Youth Authority, to study demographics of juveniles in the state. Again, I think that would be extremely helpful for us as a commission. But yeah, I don't know if anyone else has thoughts on that. Kyla, I think you had your hand up first.
I will defer to Addie first.
Okay. Addie Smith.
We can't
Addie,
hear you.
We can't hear you.
Wow, I'm so sorry. I would just note
There
that
we
bills
go.
like this are often actually called placeholder bills. So they're often created in order to have a relating to clause that can later be gutted and stuffed. And with something that's this general, that's maybe what's happening here. It's less of an actual bill with actual content, and it's more of a bill that's just there. Should later in the session, when all bills have died, it remain open and able to be stuffed with something new and moved forward.
Thank you for that input. Thank you. Anybody else with thoughts or feedback? Kyla, you still have your hand up. I don't know if
I do.
Yeah.
Thanks, Addie. I was just going to say that perhaps this might be one, and I talked to Ryan and Kelly about this, thinking about the role of the Juvenile Justice Policy Commission and demographics statewide. There's been other states that have examples. Washington is one. And I know that Ohio is another, where they've published, like, their body that is similar to our body has published demographics very specific to their state, and it's informative to the legislature. I think I provided some examples to them that they can maybe send out, but this may be good for our commission to talk about how we use our technical assistance provider, or the I don't know what you call them, our contractors that are supporting us to help us kind of think about how we want to collect and review data. And maybe it's not just an OYA, maybe it's a partnership, and maybe there's more of a broad way that we can explore the juvenile and youth statistics that impact our entire state. So I just wanted to uplift that.
No, I definitely agree with you there. I would want to see something that, if you know, we're using them for that, yeah, I would want to see it collect demographic information also for county probationers, for people who, you know, are brought in pretrial and then not adjudicated. What are those demographics? Because that's important as well. I've had plenty of cases where the kids come in and they sit in custody and then they're not found in jurisdiction and off they go. And I don't know what data we are collecting on them, but it definitely seems important if we want to gather demographics on who's being brought into the system as a whole. Molly Rogers, hands up.
Yeah, I appreciate that. I think that we don't need a bill to do that. So I think this truly is probably a placeholder bill. And then we get to say how we do that. A lot of that information is already available. We just maybe will develop our own dashboards. But Oregon is probably the number one state in the United States that has the data. So anyway, but I do think this is this particular bill is a placeholder bill.
Yeah, for sure. And I definitely think that the technical assistance that Kyla talked about is a good place to start with this. Okay, so looking at the last one on our list that was the most tracked, this one's got the most, I guess, effect in my view, even though it's really just changing one thing. House Bill 2472 takes the burden from the youth and puts it on to the district attorney for sex offender registration hearings at the end of supervision for youth. Because currently it is the youth who have the burden of showing by clear and convincing evidence that they have been rehabilitated and shouldn't have to register as sex offenders. And so this bill would flip that. So yeah, I mean, I have my thoughts, but I want to hear from some others first. I know, Lisa, you have your hand up.
Well, I was actually wondering, are we going to talk about House Bill 2677?
Was that on our most tracked? Here, let me see that.
Yeah, it was the last one.
Okay, yeah.
And I know we have only a few minutes left. I don't know if we can talk about 2677 first, if that's
people feel like that's one they want to discuss more, then that is 100% okay. Okay, so that's the expunction bill. Got it. Yeah, actually, I was kind of reading that. I got a little confused on the wording of it. So yeah, I would like to hear your thoughts on that, actually.
Okay, as people know, this is something reform that I have been working on personally for several years, and there was a large work group that some of you here have been involved in that started in 2017 or 2018, if I'm remembering correctly. And the concept of 2677 is fairly simple. There are two entities and one person who can file to expunge their juvenile record. The juvenile court can file, the juvenile department can file, or the subject person of the record can file to have their records expunged. What Oregon did was just change from the juvenile department may file to the juvenile department shall file. And when the work group started, they decided to break records into sections to not do a reform for all records. And they started with records about contacts where a kiddo had contact with the juvenile department, but there was not a formal adjudication. Those records became eligible for automated or system-initiated expunction in 2021. In 2023, misdemeanor and violation adjudications were added to this automated process. This bill takes eligible felony adjudications and then adds them to this existing process, which I think has been working really, really well. There are very limited. There are a limited number of youth who file, or they're adults when they file, to have their records expunged. And the research shows only 4 to 7% of eligible people file to get their records expunged. However, they have significant consequences for people in terms of getting a job, getting education, getting a professional license, and getting housing. So the bill is, the concept is simple, but the way it's drafted is it's so technical because it's written to avoid partial expunctions, and because partial expunctions are really very costly, and JJPC has one record for a kid. And if you were going to expunge part of that record, you would have to print the whole thing and then rebuild the parts that aren't expunged. And so part of that is why it seems it's so technical. But as an example, in terms of the numbers, last year, if I get my numbers right, and I know other people on this call can correct me, I think there were about 100 people who filed an application to get their records expunged. The automated process for misdemeanors, violations, and then contacts expunged 4,000 people alone last year. And so that shows the difference between who's eligible to expunge their record and who is actually able to apply. And I think the people who are able to apply are usually people who have some access to the system. And this is really a bill about equity. It doesn't change the criteria for expunction. It just changes the initiation and who files. But I could answer any questions, and I'm hoping there's lots of support for this legislation.
I have a question about just, I've read through it. Again, yeah, it is technical and hard to read because then I'm having to go back to the statutes and plug in where it's going to, where all those parts are going to be. But I was a little confused on the misdemeanor involving violence language, like what that is, why that was put in there,
Yes.
and if that changes eligibility criteria is the main question.
So what the work group decided for the bill, I think it's Senate Bills 575. There's 575 and 519 are the two Senate bills for the prior legislation, and sometimes I mix them up. Misdemeanors at this time, the work group did decide to change the criteria for misdemeanors, because it used to be if you were adjudicated, you had to wait 5 years after you were adjudicated for anything to file for expunction. The work group decided to move misdemeanor and violation expunctions to 18 years of age. They're usually low-level offenses, but they can cause a lot of collateral consequences. However, and at the same time, the bill changed the eligibility from 5 years to 4 years to try to reduce the amount of time that people could wait until the court was required to expunge their record. Oregon has a gun restriction law for felonies and for 5 misdemeanors that are called misdemeanors involving violence. And that gun restriction is for 4 years post juvenile court jurisdiction. I don't know how the misdemeanors involving violence is a term that's already existing in the statute. It's not something that this bill created. Those of us who know kids, menacing is one of these misdemeanors involving violence. I'm not sure when we've seen, if any of you have had contact with a kid or are aware of the facts on a menacing charge, you're like, this doesn't seem to be very, very violent. But we just took, the commitment was to implement what is and not change the criteria. So because that has a gun restriction law for 4 years, which matches felonies, the work group that met over the summer decided to move misdemeanors to then this felony adjudication. So it would mirror what follows that, if that makes sense, that there's 4 years post 4 years post juvenile court of jurisdiction for these 5 misdemeanors.
So right now, under the current law, assault 4, for example, when you turn 18, if you meet the criteria, that's automatically expungible. But under this, it would no longer be automatically expungible. You would have to then apply after 4
No,
years.
you
Okay,
don't,
that's
it
what I
will,
was confused about.
it still moves it to the automated expunction, but it moves it to this other criteria that does follow the felony adjudications. So you won't, the juvenile department won't file for expunction until 4 years after someone has been terminated from the juvenile court.
Okay. I think that clarifies for me. I don't know if anyone else has comments or questions on that one.
I think the other thing, if I can just add, what can be
Yeah, go ahead.
confusing is that the work group decided we weren't going to rewrite the entire expunction statute. And I think that there are some folks who feel like the entire statute needs to be reworked, but we left in all of the original process and we just added the automated process to it. And so the statute's getting longer and longer. But I don't think we're at a place where we can have a complete rewrite of the statute. I do think that there are some technical advances that might come in the next few years. I think that the court system might get some updates. JJPC is getting some updates. And as our electronic systems are updated, I think we have some opportunities to use those updates to promote policy and best practices. And so I think that would be a time to relook at that and then move forward. I mean, if you look at, there is an ABA Model Act on expunction. I think Oregon law doesn't follow this. In one way, it's one of the big differences is it says everything should be eligible for expunction. And there are some really, really serious felonies that would probably never fit into an automated process. But the best practice is that an individual would have the ability to expunge their record if certain criteria or are met, or there's some discretion with a court. There are lots of offenses where the court has no discretion and they're just not eligible at all. The ABA Act also points to that the timing, they are recommending that if there's a waiting period for felonies, that you look closer to 2 years. And that's because there's this balance between, well, I don't think that there's I have never found any data or evidence or research that pointed to the fact that records promote public safety. I can't find that, but there's lots of information that collateral consequences make communities less safe. The number one indicator of recidivism is joblessness. And so in some ways, we're not doing our communities any favors when we are restricting otherwise eligible individuals from obtaining an education or obtaining jobs or obtaining a house. And so I think there needs to be a balance with that. But we didn't address the group that's been working on this hasn't really addressed some of these policy issues. We're just trying to implement the current statute and current criteria. And I know Molly has been involved and Jordan's been involved and Debbie's been involved. So please, I can invite them to join in with any other information.
Well, I don't like cutting everybody off, but we are pretty much out of time, and I wanted to leave room for public comment. So if any of those people have a public comment on that, I do want to leave a few minutes here for that. And thank you, Lisa. That was, yeah, that was helpful. And Deborah, looks like you have some public comment for us.
I was just going to mark that today, I don't know if people are tracking all the bills that come in, but there was a bill filed today that's I would say a semi-repeal of Senate Bill 1008. It's House Bill 3711. I've not had a chance to really look it over, so I'm not trying to make any comment or commentary about it. Just wanted to mark it so that people could look it up if you hadn't already seen it. That was
Thank
it.
you for
Thanks.
Okay. Anyone who is present who wants to make any comment? Leave a little bit of time. All right. Thank you, Cord. That has to run. Well, all right. It doesn't seem like I'm not seeing anything in the chat. And I'm not seeing any hands raised or hearing anything else. So with that, thank you everyone who was able to make it today. Kyla, I'm glad to see you, but you probably need some rest. And yeah, thank you, Ryan. Thank you, Kelly. Yeah, we'll see you all soon. Have a good one, everybody.
Bye.
Take care.